at both times. So it's my great pleasure to introduce Tiina Kala as the next presenter. Tiina knows there's no need to do any introduction, or all you know, you have read Tiina's articles. If you haven't, so please check internet. There's a lot of good readings from Tiina, and Tiina is explaining us old documents, new meanings, and some interpretation of the 13th century Danish Royal Charters for Tallinn. Please, Tiina.
Thank you. And if you would allow, I still use Tallinn.
There's no problem. Please go.
Dear colleagues, head kuulajad, we've seen in two previous papers already how times change and new interpretations emerge about historical and historic events and documents. And in the following, I shall focus on some early modern interpretations of medieval charters, on the example of Danish Royal Charters issued for Tallinn in the 13th and 14th century. From the period until 1312, the early surviving documents issued either in Tallinn or for Tallinn are 36 Danish Royal Charters, 9 documents of other authorities, and 3 codices of Lübeck town law. It seems that during the Middle Ages, perhaps from the very beginning of the city council's existence, Tallinn's privileged charters and codices of Lübeck law were kept separate from other records, and this is probably also a reason for their survival, while other 13th century records have perished under unknown circumstances. Thus, the importance of Danish Royal Charters for history of Tallinn, especially for early history of Tallinn, can in no way be overestimated. They were issued to establish or to confer legal order of the city, to donate privileges to local institutions, especially ecclesiastical institutions, and to regulate daily life of the burghers. Most of the 13th century charters survive in original, but to estimate their legal importance and their interpretations in subsequent centuries, one should also take into account their copies and translations, which were produced in different forms starting from the first half of the 14th century, both as individual pieces of copies and as text collections, and until the first quarter of the 18th century, so for quite a long period. The earliest collection of copies belongs to the middle of the 14th century and was probably compiled when Tallinn went under the rule of the Teutonic Order. During the period of the Rhine Order, when the autonomy of the town council and its administrative capability was perhaps not seriously questioned, or as far as we know, no charter collections were compiled. They appear again in the early modern period. Some of these early modern collections were presented to central powers, respectively Swedish or Russian, to claim legal rights, donated in old charters to the city as a whole or to its one or another institution. Contemporary interpretations of documents are mostly revealed in summaries added to the copied text in those early modern collections during the period they were compiled. Such copies of medieval charters were not produced out of historical interest, but of course on practical purpose. However, from the point of view of namely these practical purposes, early modern jurisdiction, the situation was complicated. On one hand, there existed a 13th, 14th century corpus of privileged charters, of legal texts, which were still in force, or at least still not yet abolished. On the other hand, it was obviously quite impossible to strictly follow these regulations on a totally different political, economical, and administrative situation. Some documents had totally lost their relevance, the content of others might have become obscure. Still, such documents were not omitted from these early modern privileged collections, but simply either left without summaries altogether, or their content was described in very general terms without any interpretation of their meaning. The question is whether medieval documents incorporated into these collections were always interpreted during the early modern period according to their original purpose. This, in its own turn, raises the problem how those interpretations have affected scholarly understanding of these documents. To limit the scope of the investigation, I shall concentrate on two partly intertwined topics from Tallinn's early history, and this is the donation of the Lübeck town law and the foundation of the Cistercian nunnery of St. Michael's. It is common knowledge, widely and mostly unquestionably accepted, in historiography at least, that Tallinn was granted the Lübeck town law by King Erik Klofbenig in 1249. The text of the previous charter contains 4 points. It confirms the privileges donated to the city by King Valdemar, not specifying which these were, gives the burghers of Tallinn equal rights with the burghers of Lübeck, frees the burghers of Tallinn from customs duties, and fourthly, specifies that fines for affecting bodily injuries within the limits of the city's territory should be imposed on the joint decision of city councillors and king's men. Erik Klofbenig's charter does not survive in original. Its text is known according to a transact made in 1347 on the order of the provincial of the Teutonic Order, Burkhard von Dreileden, after North Estonia sold to the order. The transact contains a text of 27 Danish royal privileges issued for Tallinn during the period from 1248 up to Valdemar IV, 1245. Apart from 1248 charter, the originals of only 2 other charters contained in this transact have been lost. So most of them survive in original. In transact, the 1248 charter text is not the first in line, as you can see, but only the second one. Well, the second one here, although number 1 stands here added later, sometimes in the 17th, 18th century. The first one is a charter of Christopher I from 1255, and this charter explicitly donates Tallinn the Lübeck town law. Some of the charters copied in 1347 transact were also separately copied and legally confirmed more than once already during the 14th century, or translated into Low Middle German during the 15th century, but not the 1248 charter. The 1248 charter has been included into early modern privilege collection, but its only separate copy is a German translation from the 16th century. By the way, I have been thinking about the date of this copy. Perhaps someone can help me. Previously, I thought that it comes from the 17th century, but then I discovered it's very difficult to make difference in the scripts from the second half of the 16th, middle of the 16th century, beginning of the 17th century, and the watermark have not helped me further. Well, anyway, it comes from the period when separate copies were seldom or not made at all, seldom made or not made at all. Normally, privilege confirmations would refer to earlier acts of the same kind. However, there is no mention of Erik Klofbenig's privileges, even in a vague or indirect way, in King Christopher's charter from 1255 or any other subsequent Danish charter. The only medieval transmission of the text of Erik Lovpening's charter, except for dry leaven Strandsamt, can be found in a collection of Middle Low German charter translations from the middle of the 14th century. Here, the translation of Lovpening's charter is only the third in line, preceded by two charters issued in the name of Christopher I, and thirdly, Burkhard von Drei-Leven's confirmation of those charters of Christopher. But the way the 1248 charter has been, by the way, the 1248 charter has been attributed in this collection not to King Erik, but to King Christopher. In the early 16th century, the secretary to the Tallinn Town Council, Reinhold Korner, added marginal notes to charter translations in this manuscript. And he has clearly marked King Christopher's charter from 1255 as the donation of the Lübeck town law to Tallinn, whereas in case of 1248 charter, he mentions only paying fines to the city council and freedom from customs duties. He says nothing about the Lübeck law. Korner's remark concerning paying fines to the city council apparently reflects the practices of the early 16th century. The text of 1248 does not specify the recipient of the fine. In the 13th century, incomes from fines would rather have been divided between the city council and the king, whereas in the beginning of the 16th century, they remained in the use of the town council only. Also, in the collection of privileged translations and copies introduced in the middle of the 16th century, the issue of criminal court is presented differently from the original charter text. The summary added to 1248 text in this collection says that the charter confirms the legal right of the city council to hold criminal court and frees the burghers from paying customs duty. Nothing is said about the Lübeck law. In Drei-Leven Strandsamt, the collection of privileged translations from the 14th century, and also in this collection of the 16th century, the first charter copied is King Christopher I's charter from 1255. All this makes one to ask whether the 1248 charter, so important in historiography, was originally as important as it may seem. In early modern collections of privileged charters, the text of 1248 charter was for the first time copied as the first in line and explicitly interpreted as a donation charter of the Lübeck law only in 1668. The summary added in 1668 collection to Erik Lovpening's charter says that the document donates Tallinn the Lübeck town law, frees city from customs duties, and gives it the right to hold criminal court. The collection was compiled on the order of the city council to be presented to the Swedish king, Charles XI. Not actually the king, but the council, Regency Council, which reigned during the minority of the king. This was the period when the Swedish central government started gradually and not unsuccessfully to curtail Tallinn's own autonomy. In these situations, all means were good for the city council to try to preserve its own privileges, and perhaps one means was to show them as old as possible. Besides the fact that the original 1248 charter has been lost and its somewhat obscure wording in connection with the Lübeck town law, the document also poses other problems. The king's title here is the following. The first thought would be the scribe had accidentally omitted either a word dux or dominus from the title while copying the text into Transact. But, as Michael Maisel has pointed out to me lately, in that case the title would still be problematic, as neither dux nor dominus were used in the title of the king in connection with Estonia before the 1260s, if I understood it right.
No, they don't refer to Estonia at all. They just have the title King of the Danes and the Slavs, and the title Dominus Estonia comes in 1266.
Thank you. As most charters copied in transsub survive, the copied text can be compared with the original to make conclusions about the professionality of the scribe. And the result is that the scribe made practically no mistakes, which does not exclude that this was still the one and only text in which a large mistake occurred. The question is also whether the 1347 transom conveys the original text of the 1248 charter. If one seeks for a parallel, it can be perhaps found in Lübeck. And, well, let me remind you quickly about this known story about Lübeck. In the 1220s, the Lübeck City Council had the privilege of Friedrich Barbarossa from 1188 rewritten, preserving some parts of the original and altering others in a more favorable way for the city. Subsequently, namely these privileges in their altered wording were corroborated by Emperor Friedrich II. There is no answer to the question whether a similar thing could have happened in Tallinn, but what had happened in Lübeck was perhaps not unknown to Tallinners. The latest interpretation of the 1248 Charter belongs to the year 1729, when, on the order of Russian Central Power, copies of legal documents from the period 1248 up till 1712, that means from Erik Lovpenning to Peter the Great, were sent to the ruling Senate in St. Petersburg. The summaries of these documents reflect their interpretation by the City Council in the 1720s. The 1248 Charter is the first document on the list, erroneously dated not with the May 15, but with the 11th of May. The original date is Idus Mai. King Erik Lovpenning is explicitly mentioned as the donator of the Lübeck town law. This was a continuation of the interpretation tradition of the Swedish period, but here one step further is made in comparison to previous interpretations. The summary suggests that the Lübeck law was donated to Tallinn, perhaps already by King Valdemar. So one can read the summary in this way. It also reflects not only a shift in understanding of legal documents, but also shows new use of legal terminology, which can be observed also elsewhere in this connection, in this collection in connection with medieval charters. By the way, it seems that scholarly interest towards this 1248 charter started namely from this 1729 collection, while in historiography of the late 18th and early 19th century, the document appears namely under the strong date, the 11th of May, which has been corrected only by Friedrich Georg von Bunge in his Einleitung in die Liedfestung kurländischer Rechtsgeschichte und Geschichte der Rechtsquellen in 1849. The case of the donation of the Lübeck law is not exceptional when it comes to early modern claiming of rights and privileges containing or allegedly contained in old documents. This can be demonstrated on the example of St. Michael's nunnery, founded by the Danish crown in Tallinn in the middle of the 13th century. The foundation charter does not survive. Historical sources concerning the nunnery are very poor. Many of them could have been lost after the nunnery ceased to exist in the late 1620s. However, there survive some Danish royal charters bearing the dates from the 13th and 14th century, which confirm the nunnery's privileges and its land possessions. Some of these documents are authentic, others are forgeries from the late 15th or early 16th century. Among these forgeries, there is a fake foundation charter dated with the year 1093. Its content does not conform either with the history of the Danish monarchy or Cistercian order, or the city of Tallinn. King Erik Eivor, to whom the foundation of the nunnery has been attributed in this document, came to the throne only in 1095. The Cistercian order was founded only 3 years later. This is all very well known in the 20th century historiography. What is not so well known, or not well known at all, is that approximately the same source-critical statements were used already by the Tallinn City Council in the first quarter of the 17th century, and namely under following circumstances. In the 1620s, a dispute arose between the city of Tallinn and the Estonian nobility over the legacy of the Cistercian nunnery. Both parties intended to open a school and use the incomes from former nunnery's property to support the school. The question was who possessed right to this property. The nobility referred to certain privileges according to which North Estonian vassal corporations had allegedly always had the right over nunnery's property, extending even back before the foundation of the city of Tallinn, as there were already then noble nuns in the nunnery. Proceeding according to all rules of source criticism, the City Council demonstrated that such claims were unfounded, while neither the history of the Cistercian order nor the Danish rule in Estonia did extend back to such an early date. Although neither party mentioned any document explicitly, the dispute might have been provoked on the basis of namely this forged charter from 1093, or dated with the year 1093. However, it is not excluded that there existed also other forgeries which described the rights of the property of the nobility more explicitly than they are described in this forgery. In order to insist on the right to participate in the foundation of a school in former St. Michael's nunnery, to stress its autonomy in general and church and school matters in particular, the City Council referred to a number of royal, papal, and episcopal documents and confirmations, and among them confirmations of the Lübeck town law have been mentioned, and namely in the following order: from 1248, from 1255, and from 1257. It is not known who formulated the arguments of the City Council, but as university education was no rarity among the members of the City Council of that period, it's possible they used their internal competence. And now, before I come to the conclusion, a brief escapade. In case we assume that the 1248 Charter was originally not meant as a donation of the Lübeck law, then what was it meant for, apart from issuing regulations concerning custom duties and fines for injuries? The text of the Charter says, Remittimus ipsis, that means civicus revalia, omnia iuraque habent cives lubicenses. One thinks automatically that here the rights of the Lübeck burghers in Lübeck have been meant. However, there's a charter issued by King Erik Klipping in 1278, by which other assumptions can be provoked. I know already that you will not agree, but I'll bet. This document gives the burghers of Lübeck the same rights in Tallinn and Estonia as they had in Denmark. Perhaps the 1248 Charter donated to Tallinners not the privileges which the Lübeckers had in Lübeck, but the rights they had in Denmark. But I admit this is a pure speculation. I haven't done any further investigation on the topic. Well, new interpretations of old documents sometimes did and continuously do reflect wishful thinking, as you have seen on my own example a few seconds away. But, at least in the past, there were not always deliberate distortions of the original meaning of the documents, but simply their adaptations to common circumstances and politics and jurisdiction. The interpretation of the 1248 Charter as the earliest donation of the Lübeck law to Tallinn emerged at some point between the middle of the 16th century and early 1620s, maybe already in connections with accepting Swedish overlordship in Tallinn in the early 1560s. When obtaining confirmations to privileges from the Swedish crown was a burning issue for the city of Tallinn. Whether this charter, the 1248 charter, was actually authentic, slightly adapted by Tallinners, or maybe even totally forged, is a question for legal historians of the Middle Ages. In early modern history of Tallinn, all medieval charters, authentic or not, had equally lost their relevance from the point of view of contemporary jurisdiction. They were used almost regardless of their content on one single purpose, just to claim the right of autonomy for the city council. Thank you.
Thank you, Tiina. Learning and eloquent. Questions, please. Don't be shy. Ask. That's a good opportunity. You have the best expert on these charters right now before you. Yeah, Mika.
Just remember reading from a paper by Helle Vogt, I hope I pronounced the name right, a Danish medieval legal historian, and she said that King Eric V had the idea to use the Lübeck law as like the basis of the town law in Denmark, but could not achieve it because of the resistance in the towns. But if I remember correctly, there is at least one town in Denmark that has the Lübeck law.
Mm-hmm.
I don't remember the name. So, excuse me?
The city of Tønder.
Yeah.
Turn.
Mm-hmm. It has Lübeck law. It was the first and only city that has Lübeck law in Denmark.
So the comment, so it's not like a comment, but it seems that the Danish kings, for some reason, preferred the Lübeck law to local Danish understandings of civil law.
Tiina, you want to comment it?
Well,
Well,
I think it would be good idea for the Danish king to actually implement Lübeck law because it would be more organized and everything, and it would give him greater power over the cities. But the cities would maybe they would resist this royal stranglehold on the cities. I don't know. I just don't know. But the town of Tønder is especially because it's located in the Duchy of Schleswig. So maybe it is given by the Duke of Schleswig and not by the Danish king. So.
And also the situation in Estonia and in Denmark was apparently quite different because the local burghers were, well, mainly from northern Germany. As far as I know, not much, but still.
Still, Estonia is the only place in the whole of Livonia where we have Lübeck law, because every other town in other territories has Regan law, which is completely different. It's based on partly on Hamburg law, partly on Gotland law.
Well, at the time, the Danes conquered northern Estonia in the 1219 and so on. Lübeck was a Danish city. It was because it was part of the Danish realm at the time.
Absolutely.
Of course, Lübeck was lost immediately in the 1120s, but they still had connections to Lübeck, and so this would actually speak to that it was King Valdemar II who actually transferred the law of Lübeck to Reval, and not later kings. It could be. I don't know.
If Kurt.
Yeah. Did I understand you correct that you also suggested this formulation that they have the same law as the Lübecks? Could be not the Lübeck law, but could be the privileges that people from Lübeck had in Denmark?
Well, this was somewhat a stray idea of mine, but perhaps more deep research should have
Yeah, because I mean, but that sounds extremely interesting. Also, in the sense, then what would be the next step? It would be to see what privileges did the Lübeck have specifically in Denmark compared to other groups, and that could be, I suppose, there must be some agreement after 1226 with the loss of Lübeck, that's the Danish perspective, but the Lübeck choosing to be part of the empire, not of the Danish. There could be some idea perhaps to see what did they get of privileges from the Danish king in that connection. It's a really interesting idea.
Yeah, because, well, as you've seen on the slide, the wording of the documents is different, not that different. And, well, it depends. In some cases, the privileged charters practically copy previous formulations. In other cases, they do not. Well, this is not a strict argument against this idea that the formulation is not exactly the same. And as it can be demonstrated on the example of that title of the king, there's something wrong with the formulation of this document. Anyway.
If I may intervene here and ask a question, not only to you, maybe I haven't read so well inside the literature, but what are the differences, similarities, or is it absolutely the same if we use libertates and if we use privilegia?
It depends.
Our most baked medievalist Mikkel, what do you say about?
Well, just the meaning of the word is, as far as I know, privilegia can also mean just a charter as like the existing document. It does not necessarily mean the content. It can only just mean bring your privilegia, bring your charters, for example. It has more a wide range of meanings.
But what about libertates? Can it be, let me say, the first phase of enlarging the legal, let me say, Lübeck? First starting with, it's in, as you know better than I, that there's libertates are mentioned in various Danish privileges and charters of the 13th century. This is first. Due to Wilhelm Abel, Lübisches Recht, first volume, he tries to convince that there are several stages of enlarging the Lübeck civic law. First starting, well, maybe fitting the local circumstances here in Tallinn River. Not exactly the same as 100% the same as it was for Lübeck. But
well, in some cases, these different words, as libertates or privilegia, they can be used just to enforce it rhetorically, to formulate it more impressively, just to use these pairs of words. Jura et libertates, privilegia et jura, and so on. But what concerns this introduction of the law, so to say, step by step, then the codices of the law, they do not cover all possible fields of the city life at all. Right. So it's, the codex of the law or any law of that period is rather of a symbolic value, and if you know how the Lübeck law emerged, just not in a systematic way, but just adding new paragraphs according to the need. So it wasn't any kind of a systematic presentation of different regulations, but it was understood from the very beginning that a codex cannot cover all those fields, but oral tradition and all kinds of other different possibilities of introducing this legal order in one another city.
That's it. Any more questions? Anu?
Please forgive me my ignorant question. I would like to ask about this forgery of 1039 of the Cistercian, of the foundation of the Cistercian order. As you know, I have a very bad memory, so could you please tell us once again when exactly was this forgery made, why at that time, and what did they hope to achieve?
It is not an ignorant question, but it's a question impossible to answer. Well, I can only say as much as I know, or as much as I presume to know. As you know, this is not a one and single forgery. There are other forgeries too. Some of them of much better quality, technically better quality than this one. And when these were made, no idea, as I suggested in the paper, in the end of the 15th, beginning of the 16th century, but also perhaps maybe in connection with the Reformation in the 1520s, when the position of the nunnery became unsecure. The script, which is the first and foremost testimony of this document being a forgery, you even don't need to go into these details when one another king came to the throne or when the Cistercian order was founded. But the script tells from the very beginning that it can't belong to the 11th century. It has been suggested, if I remember it correct, that perhaps these forgeries were made by a female hand, which means that they emerge within the succinct circles of the nunnery itself, and were not produced, for example, by the vassal corporation. And I would think rather this could be the period of the Reformation, but there is no such clear reason for such a series of forgeries before the Reformation.
I have examples of the same thing about forgeries from Denmark, and they recreate charters which have been lost, and then they recreate them as best to the knowledge what actually it says in the in the document, but maybe they add a little line to give them small additional privileges, or maybe then they get the date wrong. But this massive fault, because 1093, I wouldn't assume this is a simple recreation of a document. So I can't really see that that would be the case. But I know of examples in Denmark where they do that.
And there are a couple of forgeries from St.
Forgeries
Nunnery, which content is all right. So they name several villages in North Estonia allegedly belong to the nunnery. Perhaps they did belong to the nunnery. Perhaps some of them did. Perhaps some of them didn't. These are quite well composed forgeries, I would say. And this one is really an amateur one. So it's even a bit strange how they came to that.
I think when you have a good copy where they only make small changes, then you have the original document on your desk, and then you make the new one, and then you roll back the old one and put it back in the cupboard. But the other one where there's massive mistakes.
And furthermore, there was a bunch of forged charters, not only a single one, but makes the case much more interesting.
At least one of them has a line about liberating the monastery from any kinds of service towards the king, which is not in any other charter the Danish kings had given to any other monastery, because as far as we know, they had to do some sort of like military service, some sort of service.
Was it not about the military service? The military service of the peasants belonging to the nunnery?
Yeah,
Mhm.
but that is also one of these forged charters.
Mhm.
So I don't think I've ever seen such a thing in any of the original ones. So this could be one of the reasons, you know.
I can't quote by heart anymore some readings for 40 years ago, but still, if I remind on Paul Johansen's notion how the downtown of Tallinn was enlarged and whose possession actually St. Michael was it on the possession of vassals or something? But I stop here because it's already introducing the next paper. Any questions more now? Thank you, Tiina. Let me end it. Let's thank once